my submission is twofold. One, this reference is on the context of Tej Prakash, my lord.
Yes, yes.
Tej Prakash doubts Manjushri on two grounds. One, Tej Prakash assumes in para 12 that Manjushri says if there is no minimum cutoff, then the 10 best people, 13 best people have to be appointed. With utmost respect, my lord, Manjushri doesn't say that.
Yeah,
So the first ground for referring Manjushri to a larger bench, with utmost respect, may not arise. Second, my lord, Manjushri in Tej Prakash, the second reason given for referring Manjushri is stating that Manjushri does not notice Subhash Chandra Marwa. With utmost respect, Subhash Chandra Marwa deals with a completely different situation. Now, my proposition is this, before I read the note, my lord. Manjushri deals with a situation where the selection committee fixes a cutoff mark before they get into the select list. So there is a process. The candidate has a right to be considered, but that right is curtailed by introducing a benchmark after the viva, after the written test, and therefore the candidate does not get into the select list.
Before consideration.
Before consideration. That is the issue in Manjushri. Whereas Subhash Chandra Marwa is a case where the candidate got into the select list. Once the candidate got into the select list, then the appointing authority applied a benchmark and said we are appointing only the top 7. So there the principle of no indefeasible right to be appointed, etc. comes only in the case of Subhash Chandra Marwa and not in the case of Manjushri. That is the difference. So Manjushri, there is no mistake committed by Manjushri in not referring to Marwa because Marwa does not deal with the situation at all. So that
Marwa was a case where the authority, after the process was over, said we'll appoint the top 7.
Correct. There also, it's not like the candidate is remediless. So in that case, suppose there were 7 candidates. The appointing authority, that's the government, says I'm appointing number 1, number 5, number 7.
That is then a problem.
Of course, it can be challenged on the ground of
Pick and choose.
Yes. So, but this principle of changing the rules of the game, etc., does not arise in that case. So, in Marwa, what has happened is the rules provided only one thing, which is you write the exam, you get 45%, you come in the select list. So, in Marwa, after this exam, 40 people got into the select list with 45% marks, out of which there were 15 vacancies. The 15 names were forwarded by the High Court to the government appointing authority. Government says, because on the facts of that case, on the previous round, you had said 55%, High Court itself said, whatever the reason is, the government said, we are now applying 55%, and they took number 1, number 2, till number 7. So the candidates who were in that list, the 8 to 15, they said there were 15 vacancies, I was in the 45%, you should have appointed me. There the court said, no, this is not fixing a cutoff, this is the appointing authority selecting the 7 best people. There is no right for you to be appointed, therefore you have no case. So with utmost respect, so to say that Manjushri is not good law or is doubted because it did not consider Subhash Chandra Marwa may not be entirely legally sustainable is my submission. So there are 2 reasons. These are the 2.
Have you formulated?
Yes.
Let's read that.
Just okay. Can I just say one more sentence?
There are 3, then you can.
Yes. In this context, this honorable court in the said reference order doubted the correctness of the principle laid down in Manjushri for the following reasons. 1. That a strict application of the principle of law laid down in Manjushri would mandate that the High Court was bound to recruit 13 of the best candidates out of 21, irrespective of their performance. 2. That the judgment of 2 judgments of this Honorable Court in State of Haryana versus Subhash Chandra Marwa was not brought to the notice of the Honorable Court in Manjushri. It was observed that in the case of Subhash Chandra Marwa, while dealing with the recruitment of district judges for the State of Haryana, it was held that the government, while making appointments from the list of eligible candidates, can fix a score which is higher than the eligibility with a view to maintain higher standards of competence. It is humbly submitted that the same is an incorrect interpretation of the ratio of Manjushri for the reasons below. 1. The judgment in Manjushri does not lay down an absolute proposition that in the absence of minimum qualifying marks, the best candidates must be appointed irrespective of the marks scored by the candidates. It is settled position of law that there is no indefeasible right of a candidate to be appointed, and Manjushri does not state anything to the contrary. 2. The decision in Manjushri arose in the context of recruitment to the post of district and judges in Andhra Pradesh State Higher Judicial Service, where after the written examination and the interview were concluded, the subcommittee of the full court introduced the requirement of minimum marks for the interview, and as a result of the same, the candidates with higher aggregate marks were kept out of the merit list based on their marks in the interview. The principle of law that rules of the game cannot be changed once the game has been played was laid down in Manjushri and was applied at the stage of preparation of the merit list during selection before the said list were sent to the state government for appointment. That is the distinction, my lord. Now, 4.3. Further, this honorable court in para 33 of Manjushri categorically holds that prescription of minimum marks for interview is not illegal. It further holds that the authority making rules regarding selection can prescribe by rules the minimum marks both for written examination and interview, or prescribe minimum marks for written but not for interview, or may not prescribe any minimum marks for either written examination or interview. It is specifically held that where the rules do not prescribe any procedure, the selection committee may also prescribe minimum marks for the interview, but before the interview. In this context, it is submitted that the judgment in Manjushri cannot be doubted for not considering Subhash Chandra Marwa for the following reasons. 1. Subhash Chandra Marwa was a case where the appointing authorities of the state government adopted a yardstick of minimum marks in exercise of its discretion to make appointments from the list of eligible candidates prepared by the Public Service Commission, and the relief was denied to interested candidates on the settled principle of law that there is no right of appointment in a candidate merely because the vacancy was indicated. B. The said factual situation is different from the case in Manjushri, where the criteria were changed while preparing the merit list to be sent to the state government for appointment. In this regard, this is important, my lord, reference may also be made to the opinion of Honorable Justice Owens in the split decision of the two-judge bench of Salam Sarabjit, where it was observed that the judgment of Subhash Chandra Marwa applied only in cases where selection procedure had been completed and thereafter the appointment is denied for good reasons. Now, just one sentence to add here, my lord. In the same judgment, Justice Bhanumati's judgment, which basically she in that judgment, para 25, what is said in that was a case where the marks was prescribed before the viva. So Justice Bhanumati, while dismissing the case of Salam Sarabjit, says, had it been a case where viva marks were fixed after the interview, the position would have been different. So the decision in that case was Justice Bar, even though the
It doesn't apply Manjushri.
It applies Manjushri. It says on the facts of that case, they are not applying Manjushri because in that case, viva marks were fixed before the interview. Whereas in Manjushri, it was fixed after. So I'll read para 30 later. In para 30, there is one line where the specific sentence is para 25. Sorry, para 20 with a specific sentence which says, had the full court met and fixed the viva marks after the interview, the position would have been different. So that is the basis for that distinction. There's no other reason why Manjushri was not applied on that reason, my lord. Now, my lord, the next question that arose in the last hearing, my lord, was whether the Manjushri endorses Umesh Chandra Shukla. So then the question arose whether if there is a conflict, Lordship, remember last time, if Manjushri endorses Umesh Chandra Shukla, and if Umesh Chandra Shukla and Subhash Chandra Marwa are conflicting, then what do we do? That was the question. Now, my respectful submission to that, Lord, is there is no conflict between Umesh Chandra Shukla and Marwa. Umesh Chandra Shukla was a case similar to Manjushri. That was a case in which the selection committee, after the interview, after everything, before the list was sent to the government for appointment, introduced an aggregate of 600 marks for written and viva. And based on that aggregate, many people who otherwise would have been eligible to be considered for appointment were not put in the select list. So the question that Umesh Chandra Shukla is similar in facts to Manjushri, whereas Tej Prakash is similar in facts to Subhash Chandra Marwa. So in this case, in Umesh Chandra Mishra, what this honorable court held is, you have no right, you have a right to be considered. You cannot interdict that by introducing this cutoff when the advertisement, etc., did not provide for it. Even that judgment, para 14, specifically, I just read that sentence. The question whether a candidate included in the final list prepared and forwarded by the selection committee may be appointed or not is a matter to be considered by the appointing authority. So what the difference is this, my lord. One set of cases, there is a barrier created before a candidate gets into the select list. Those are governed by Manjushri, Umesh Chandra Shukla, etc. The law says you cannot do it unless the rules prescribe, etc. The second are the kind of cases where after you are in the select list, The appointing authority fixes a cutoff which was not there earlier and says, I'm appointing only 5 out of 13 vacancies, or whatever the reason is. There, the issue of change in rules does not arise. But however, like I said earlier, my lord, the candidate is not remediless. The candidate still has the principles of arbitrariness, Article 14, all that is available for him. If it can be shown that that criteria, that cutoff prescribed by the appointing authority was for any other reason, was to favor one person. One example, obvious example, which I said earlier, my lord, if they don't follow the inter se merit, if they take 157, it's a ground for arbitrariness. Or they fix out of 100 marks, they fix 99% as the cutoff, and they take only 2 people. Maybe a ground for arbitrariness. That depends on facts of each case. But this principle of change in the rules of the game after the game has started does not arise in cases of Subhash Chandra Marva and in the case of Tej Prakash Pathak. So there is no conflict between Umesh Chandra and
Now let's go to para 6 of your
yes, my lord. Can I read 4.5 for a second?
4.5. All right.
That's only distinguishing each of them. You are saying.
What I'm saying is why there is no conflict between these two, my lord.
All right. Can formulate it.
I'll quickly yes.
In a minute you can read.
Yes. Similarly, there is no conflict between the 2-judge bench judgment of Umesh Chandra Shukla relied upon in Manjushri and the 2-judge bench in the case of Subhash Chandra Marva, as is evident from the following. A. The judgment in Umesh Chandra Shukla arose in the context of an additional requirement of minimum aggregate marks, which was introduced by the selection committee after the selection process were completed for the post of so-and-so in daily judicial services. The said judgment did not pertain to the discretion of the appointing authority as in Subhash Chandra Marva. It is specifically observed in Umesh Chandra Shukla that the question of whether a candidate included in the final list prepared by selection committee may be appointed or not is a matter to be considered by the appointing authority. In any case, the judgment of Umesh Chandra Shukla refused the application of the additional requirement since the High Court of Selection Committee did not have the power to prescribe minimum marks under the rules. Now, Subhash Chandra Marva is an authority for the proposition that the appointing authority can choose to fix a higher benchmark while appointing candidates from the merit list, whereas Umesh Chandra Shukla is an authority for the proposition that no cutoff can be prescribed by the selection committee after the selection process started if the rules do not permit so. Therefore, it is respectfully submitted that both Subhash Chandra Marva and Umesh Chandra Shukla operate in different factual scenarios and there is no conflict whatsoever between the said judgments. Furthermore, the judgment in Tej Prakash is similar to the judgment in Subhash Chandra Marva since the High Court, that is appointing authority under the staff rules, decided to employ the yardstick of minimum marks for appointment of eligible candidates and there is no conflict between Tej Prakash on one hand and Manjushri and Umesh Chandra Shukla on the other. It is submitted that Tej Prakash and Subhash Chandra Marva deal with a situation where the benchmark is introduced by the appointing authority after the candidates are included in the select list, whereas Manjushri and Umesh Chandra Shukla deal with a situation where a benchmark is introduced by the selection committee before the candidate is included in the select list. Therefore, the principle of law that there is no indefeasible right of a candidate to be appointed applies only in case of Tej Prakash and Marva and not in the cases of Manjushri and Umesh Chandra Shukla. In view of the above facts and circumstances, it is humbly submitted as follows. A. The judgment in Manjushri is similar to Umesh Chandra and the judgment in Tej Prakash is similar to Subhash Chandra Marva. As a result, the observation in the reference order dated 23/2013 in Tej Prakash that Manjushri is not good law since it did not consider Subhash Chandra Marva is misplaced. This honorable court in Manjushri has rightly considered and endorsed the judgment of Umesh Chandra and similar judgments and laid down the principle that rules of the game cannot be changed once the game has been played. Furthermore, the interpretation in Tej Prakash Pathak and Manjushri laid down an absolute principle of law that in the absence of interpretation in Tej Prakash, that Manjushri laid down an absolute principle of law in the absence of minimum qualifying marks, the best candidate must be appointed, irrespective of the marks scored by the candidate is erroneous. Therefore, respectively submitted reference to be answered by holding that Manjushri is correctly decided and lays down good law. Now, 6 Lordship had asked us to see what are the safeguards which we can think of, my lord. Further, this honorable court may consider providing the following guidelines as the way forward. In a selection procedure consisting of written examination and viva, the relevant para 6. The relevant recruitment rules for selection should provide for minimum cutoff marks for the written examination, the interview, and the aggregate of written and interview if necessary. B. However, if it is not feasible to prescribe minimum cutoff for every stage of selection process as a part of the rules or at the stage of advertisement notification, then 1. The minimum qualifying marks for the written examination should be prescribed before the commencement of the written examination. B, the minimum qualifying marks for the viva should be prescribed before the commencement of the viva. And C, if the minimum aggregate marks for the written examination and viva is required to be prescribed as a precondition for being placed in selection list, then the same should be prescribed before the commencement of the written examination.
It's a little more.
C, my lord, sorry. C, my lord, C. In cases where cutoff is being prescribed for viva before the commencement of the viva, but after the written examination, then the same should be duly intimated to the candidates by way of a notification before the commencement of the viva, and the reasons for the same also ought to be disclosed. D. Additionally, in this regard, it must be ensured that applicable selection rules empower the concerned selection authority to fix such minimum marks for written examination, viva, aggregate of written and viva before prescribing the same under 6B above. If the original advertisement prescribes selection by way of written examination and viva, under no circumstance can the process be changed subsequently to only written examination or only viva after the selection process has commenced. Now, these are some of the safeguards which we could think, I would think of, my lord, before. Now, just two,
This
three
is the
other
only
points.
way you can balance the power vested with the state under the services under the state,
Yes, my lord.
where our constitution contemplates concept of a pleasure doctrine for the purpose of appointment, which means that the state has an absolute power to determine with flexibility to pick up the best of the candidates. So
Yes.
therefore, it's not bound by the contractual relationships.
Yes.
So where such a freedom is given, it must have, it should be reflected in the selection process also.
Yes.
So, but in the selection process, if you are giving the freedom, it must not be arbitrary,
Yes.
but it can be at each stage some kind of a control.
Yes.
As you would suggest that if the rule prohibits, matter ends there.
Yes.
If the rule is not there, the silence will not do, but it must be an enabling provision.
Yes.
If it is an enabling provision, then it may do it before the written test is taken. If they want to impose a cutoff mark, they must specify it, give reasons,
Yes.
and then permit them to take written test.
Yes.
Similarly, they must follow the procedure for the oral, the viva voce also, intimate in advance and give the reason why it became necessary to impose it. So much so that both these,
Yes.
the rights and rights of the state as well as the duty of a state
Yes.
with the
Surprisingly, this issue keeps arising when you work on it. This issue keeps arising, and surprisingly, large number of cases in the context of district judge selection. I don't know what the
most of
it
the
keeps happening. Himani Malhotra, Ramesh Kumar, n number of cases in the context of judges selection.
But as experience,
Yes,
more than me, my learned brothers and Honorable Chief Justice was indicating, much of the method of picking the best will arise when you interview a
Yes.
candidate.
Yes.
Similarly, as you know, we get the best of the points when we hear you also. So therefore, one-to-one interaction.
Now, the
perhaps is
Ramesh,
the best.
sorry, the Ramesh Kumar judgment which Haripriya read, my lord, that was a case in which the advertisement specified minimum marks for the viva. Still, this honorable court went ahead, set aside that, say, applying Manjushri on the ground that rules did not prescribe.
That's wrong.
Yes, that Ramesh Kumar, it's lucky because, you know, the rule says minimum viva.
For the
Still,
volunteer, misconception.
now, they applied Manjushri. Actually, Manjushri doesn't arise in that case. It is not a case of Manjushri. But still, now there are other judgments, my lord. For example, Manjeet Singh, which he read, my lord. Now, Manjeet Singh also, it doesn't discuss the issue in detail, but even that is a case where the petitioners were included in the select list and thereafter they introduce this 40% for the interview. So many of these cases, my lord, with the most respect, can be distinguished by looking at what stage. At any event, selection committee, Manjushri only says selection committee cannot do that. And with utmost respect, that is Tej Prakash's reasons for doubting it may not
We
entirely.
get the point. Thank you.
Thank you, Ms. Veerasan. Thank you.
Oblige.